It's Tuesday, February 7th, 2023, and I call this meeting of the Senate Elections Committee to order. A quorum is present. Today we have one bill on our agenda, and that's the continued discussion of Senate File 3. We've spent 2 full committees on this bill already, and my intent is to have the committee vote by 4:55 or earlier, so we want to get it finished today. When we left the discussion on Tuesday, Senator Curran had offered an amendment, and I want to compliment Senator Curran because he worked with the bill author, and they came to an agreement with some improvements to the bill. And you know, that's what we want here, is we want to have people working together, and I appreciate, Senator Curran, your dedication to that. So when we left the discussion, you had the amendment, and I'm going to understand that you have a different amendment because you pulled the last one. Would you like to cover the new amendment?
Mr. Chair, I just have to find, did we renumber it? It is 41, thank you. Mr. Chair, I would like to move the A41 amendment to Senate File 3.
Senator Cran moves the A41 amendment. Would you like to discuss the amendment while it's being passed out?
Thank you, Mr. Chair. And while they're doing that, and really what this did, and I appreciate the Secretary of State as well for providing the guidance and the willingness to accept the amendment. But what this does is it makes available for all of the absentee ballot applications and provides a clarity that those that are registered or that are pre-registered or pre-enrolled in the voting system that was covered, that data was public. This just clarifies that those that then subsequently submit a request for absentee ballot, and those that any time in the year, even for a permanent absentee ballot from that point on, and or just those absentee ballots for that particular election season. So all data is public, and so that was our intent, and would encourage a yes vote.
Thank you, Senator Cran. Senator Boldon, would you have any comments on the amendment?
Thank you, Mr. Chair, and thank you, Senator Cran, for your collaboration. I think this is a good idea. I appreciate being able to have the opportunity to work together and see the language, and with the input from the Secretary of State's office, I also would support a green vote.
Thank you. Senator Cran renews his motion on the A41 amendment. All in favor say aye.
Aye.
All opposed, nay. The motion, or the amendment, is adopted. Thank you, Senator Cran. And we also had some questions from Senator Rest in the last committee meeting. Senator Rest, would you like to offer your amendment or give some discussion to the amendment?
Thank you, Mr. Chairman. I move the A39 amendment.
Senator Rest moves the A39 amendment.
Mr. Chairman, I worked with the Senate Council and also with Secretary of State's office, and I think my concerns have been answered, and I've chaired the amendment previously with Senator Boldon.
Senator Rest, do we have the amendment?
It's in the packets.
Copies of it? Okay, thank you. Senator Rest.
I had raised the issue of what does it mean to say at least monthly, and lines 1.3 through 1.8 deals with that issue in 2 separate places to change it to, instead of at least monthly, for the folks to choose a day of the month and do it by the same day of the month. And so you wouldn't have a report being given on March 31st and then April 1st and think that you had satisfied that. So pick a day of the month and then do it on that day every month. And then I had questioned what does it mean to say complete information, and it was suggested to me that to include a minimum of information that would satisfy that, that requirement to say that the publication must include, at a minimum, information on what types of charges and convictions after a person's right to vote and how the right to vote is affected and where and how to register to vote. So it's providing a definition. Then I had raised an issue about if we would be dating ourselves by just saying by telephone or email, and instead that the ballot board, if you're looking at lines 113 through 115, that the ballot board would contact or must contact the voter by a method or methods of communication provided by the voter. So the voter will say, if something's the matter, call me, email me or call me or something, but the voter would provide the means by which someone from the ballot board would contact them. And then line 16 through 18, currently Spanish, Hmong, and Somali are the three most commonly spoken non-English languages in the state, but that may change over time. And instead of that, the Secretary of State suggested having a definition for what that would be. So at any given year, it would be the three most, the information would automatically be provided to the three most commonly spoken non-English languages that are determined by a non-partisan person, and that is the state demographer. So I think that my concerns were answered without doing any damage to or making any changes really to the purposes that are expressed in the bill. So, Mr. Chairman and members, that's my A39 amendment.
Thank you, Senator Rest. Senator Boldon, any discussion?
Thank you, Mr. Chair. Thank you, Senator Rest, for
Sure.
the input. I appreciate the collaboration and would encourage a green vote.
Thank you, Senator Boldon. Any other comments from the members? So Senator Rest moves the A39 amendment. All in favor, say aye.
Aye.
All opposed, say nay. The motion is adopted. Now let's go to the bill author.
Thank you, Mr. Chair. I would move the A42 amendment, which is a technical amendment related to the language provisions in the bill in coordination with the state demographer, just altering the phrasing just a bit to make it actually work and do what we are intending it to do. So it does not change the intent or workings of the bill. It's a technical amendment.
Senator Bolton moves the A32 amendment. A42. Okay, I'm sorry, I have it. Senator Limmer.
Mr. Chair, this is not the committee of original jurisdiction, is it?
It is, however, we've already heard the author's amendments, so this is an additional amendment, so I don't think it gets the same
Doesn't
class.
get the author amendment treatment.
It is, pardon me?
Does it get the author's amendment treatment?
I do not believe so, because it is,
Right.
we've had other amendments since the author's amendment.
And it has gone to other committees?
No, not yet.
Oh, not yet. Okay. I'll just wait for an explanation of the difference between the original text and the delete everything amendment.
Okay.
Are we on to A32? 42. Oh, I misheard it, Mr. Chair.
A42.
I'll withdraw my question.
The amendment is the A42, and it's amending the delete everything amendment, the original amendment. So even though it says delete everything, it's the amendment of the delete everything.
I had not heard the amendment. I thought it was the A32 that we were entertaining.
Oh, sorry.
presently.
I did read A32 because it did say that on the top of the page too.
So
So-
what amendment are we on, Mr.
We are on the A42.
42?
Yes, the A42 amendment.
Thank you.
Any further questions from the members? Senator Matthews.
Thank you, Mr. Chair. So I'm wondering if we could back up. We're saying it's a technical amendment, but as we're sitting down and trying to pull out the original delete everything amendment, could someone please go through what section and what this is a technical fix for, just so that we understand this?
Senate Council will cover the differences.
Thank you, Mr. Chair. Organize my paperwork a little bit here. So the first several lines, line 1.3 to 1.6, amend two different sections related to permanent absentee voter lists. So as you remember, the bill changes from a permanent application to a permanent absentee ballot. And most of those provisions in the A32 amendment had an effective date of June 1st, 2024. And inadvertently, it got left off of these two sections. And you'll see those two sections on page 14 and 15. The next set of lines are on page 19 and 20, and these all have to do with the section relating to having interpreters and, lost my train of thought, having interpreters and translating materials into different languages. The A32 amendment changed, the underlying bill talked about identifying languages by school districts. The A32 changed that to census tracts, but the state demographer looked at that and said there were a few other changes that needed to be made to make the census tract workable. So changing a few other things, like looking at the percentage instead of the number of people, getting rid of voting age and looking at other population more generally. And then there was on lines 8 through 10 of the A42 amendment talking about how language minority districts will be appointed. And that comes from the state demographer as well. And then there is a change at somewhere in here about changing on line 11, the A32 changed election judges to interpreter, and this is just fixing the head note to reflect the changes that were already made in the A32.
Senator Matthews, follow up? Thank you.
Mr. Chair, I do
Senator
have
Grant.
just a quick follow-up. So on the, I'm just getting here, I think it's page 29. Oh, no. The percentage of where we remove voting age on line 28, 3% of those at voting age, we just basically have residents. But from a voting perspective, the district may change pretty dramatically in the younger age in the tracking of those of the residents under the voting age, under 18. And so wouldn't that skew the need for interpretation services if the target was 3%?
Senator Boldon.
I'm just looking at the population, because the voting age population will, of course, follow the younger population. And so if we remove the voting age and we measure just total population, it will likely be at a much higher percentage of determination of need, when in fact, of those voting age, it won't reflect the actual need of the voting age people. So I think it will likely increase the need unnecessarily earlier in the process for those counties to be prepared for the interpretive needs based on the total population relative to those of voting age, those that are actually going to be voting in that election. So I would just wonder what the intent is in
Senator Boldon.
Senator Chair, Senator Cran, this was the direction we were given from the state demographer to do what we are looking to do to determine, where that 3% threshold is. This was the language provided by the demographer to do that.
Mr. Chair.
Senator Grant.
Senator, yeah, and I think I agree. I mean, it looks like it's following down the intent, so we don't have to be here every year modifying those things, and that is baked in and it can be dynamic. But it could be a pretty significant difference between those as far as just total population of any district to those in voting age. And so we could determine easily that they need twice as many interpreters based on the entire population relative to those actually in need in an election. I think it'll be create a difficult situation in filling those in many cases or many places already. So maybe a word of caution. So thank you.
Thank you, Senator Cran. Senator Rest.
Thank you, Mr. Chairman. I would just like council to read how subdivision 3 would read with this amendment. I'm trying to scratch out lines and put in information. It's a pretty long sentence, but I wonder if you would read the amendment as it would be written in the bill. The amendment lines 111, 12, and 13, which are on page 19, and actually it's subdivision 3. I wonder if you could read what that would be, Ms. Stengel, Mr. Chairman.
Senate Council.
Thank you, Mr. Chair and members. So the new subdivision heading would read, translation required, interpreter required. If the number of residents determined under subdivision 2 equals 3% or more of a census tract, or if interested citizens or organizations provide information that give the Secretary of State, and then the rest of it for that page goes on to be the same.
Senator
Okay,
Rest, follow-up?
thank you, Mr. Chairman. That's very helpful.
Thank you. Any other comments from members? Senator Anderson.
Thank you, Mr. Chair. Senator Boldon, it says a census tract. What's your definition of a census tract?
Senator Boldon.
Thank you, Mr. Chair. Thank you, Senator Anderson, for the question. I might defer to Senate Council for the exact definition of census tract. However, again, this was language provided by the demographer in order to do, what we are intending to do to measure. As was shared initially, we had used the boundaries of a school district, but in conversation with the demographer, it was suggested that it would be more workable and we'd be better able to be effective with this process to use the census tract, which is a term used in other places outside of just this bill.
Could the Senate Council give us some information on census tract, please?
Yes, thank you, Mr. Chair and members. There are various ways that the census breaks down how they count people. The very smallest is a census block, which are just a few people, and those are sort of pieced together in a different way. But census tracts are sort of a grouping of the blocks, and they usually have about roughly 4,000 people or so in that tract.
Senator Anderson, follow-up?
Thank you, Mr. Chair, Ms. Lexis. Is that for across the state, or is that just locally?
Mr. Chair and members, the whole state is divided into census blocks, and then they're grouped together in census tracts. And census tracts are roughly the same size across the state and across the country. The census does that in the same way.
Thank you.
Thank you, Senator Anderson. Thank you, Senate Council. Senator Matthews.
Mr. Chair, I'm wondering if maybe is the state demographer here, or can the committee reach out and ask, because the committee has a number of questions that have come up. The author doesn't have the answers, pointing to council who's saying, well, the language is coming from the demographer, so maybe we could get to the source and see if questions could get answered so that we understand this.
Do we have anything from the demographer here? In Senator Boldon, did you get that directly from the demographer, or did you get that from the Secretary of State's office?
Thank you, Mr. Chair. This language was from in collaboration with the state demographer, and certainly in collaboration with the Secretary of State's office as well.
Would anyone from the Secretary of State's office care to comment? Thank you. Please identify yourself for the record.
Nicole Freeman, Office of Secretary of State, Director of Government Relations. As Senator Boldon said, the recommendation was to take and as Senate Council mentioned, the census tracts are a universal, not universal, a unit of measure that is the same across the state. And those census tracts will allow a better look at what what the precincts, the needs of the precincts and more local areas will need. And so that's why we took the census tract as opposed to school districts, which oftentimes school districts span county lines, precinct lines, and things like that. And so these census tracts are a better way to get that data related to languages that are spoken.
Thank you, Ms. Freeman. Senator Matthews, follow-up? Does this answer your question?
Mr. Chair, I do have a
Grant.
follow-up. Thank you, Mr. Chair, and Ms. Freeman, now that you're up here. So it appears to be a deviation from what we have had in the past, and it appears that you've at least been consulted. To my earlier statement, based on without making that determination of voting age, won't that prematurely determine a need that doesn't exist for voting age people by counting all people in a particular census tract?
Ms. Freeman.
So I guess I can't comment on how it might impact or what the threshold should be. I'll leave that to the bill author to determine what the percentage threshold should be when, new services might be required. But I understand your question about, yes, it would include people of all ages in that area as opposed to voting age.
Mr. Chair, follow-up.
Senator Grant.
Ms. Freeman, but it appears that you've been consulted with this, so there must have been some analysis done in your office before you determined a favorable opinion on moving forward with removing voter age in determination of need for interpretive services. I just want to make sure that everybody who's going to fall into that, because I'm really worried about something that's truly measurable and determination of need, because I'm worried about some language in here too that says if other interested parties may determine a need. We want to know that the criteria in which the Secretary of State is going to dictate to our facilities, cities, and counties who manage elections. We want that to be understandable and reasonable, and then meet the need of the time of the voters that are eligible for that particular election period. And so I'm a little bit concerned that would like a more detailed analysis of what impact do you think that will have? It's a pretty big change from what your standard policies have been in the past. So.
Ms. Freeman.
Thank you, Mr. Chair and members. So we went with this level of data as the general population is what is counted in the census, of course. And so that's what data would be available with this level of language minority districts. That's sort of where that data is kept and at what level that data is kept. As far as how this would impact local jurisdictions across the state, I can't speak to that right now. I can get back to you and provide more information, but we haven't ran the calculations to determine where that might.
Mr. Chair, a quick follow-up.
Senator Grant.
Thank you, Ms. Freeman. And these are significant policy changes that impact the state, and so I would hope that that analysis is done before the favorable opinion to move forward with this is determined. And so it would be helpful for us because its impact, it varies all over the state, and we want to make sure everybody is prepared to meet this. And so we'd hope that you provide the detailed data in that analysis next time. Thank you.
Thank you, Senator Krantz. Can I ask you a question about your concern? Are you concerned that if you have a larger group involved in the track, that perhaps you have more English speakers, for instance? Because
Mr.
children
Chair, just the composition though, right? You have a household of 5 or 6. You have 2 of voting age in any particular election cycle. That household of 6 will be determined in the classification of language need, right? And so you add that up in the totality of those voting age relative to any population, right? Just take the average 2 kids and it would double that, the need or determined need at an election cycle, right? I mean, that's what I'm concerned about, and that it's timely and that cities can ramp up for the actual need based on the intent of the law and not have to have double the number of interpreters, interpretive services for any given election time, because only those eligible shall need those.
Thank you, Senator Green. Senator Westman.
Thank you, Mr. Chair. Ms. Freeman or Senator Boldon, but my understanding is that if we tried to do this based on voting age, the difficulty is we may not have that data. Is that correct? And the place, as if I understood Ms. Freeman correctly, is the place where the data resides is in the census information. Do I have that right?
Senator Boldon.
Mr. Chair, Senator Westland, yes, that is my understanding. As I said, we, in collaboration with the state demographer and in trying to make this workable to be sure, and just to sort of regroup and reground ourselves, and what we're trying to do here is be sure that everyone is able to vote in the language, in which they are comfortable. And so making sure that we are providing those interpretive services and translative services for people in communities where they are needed. Yes, the data that we have and will get is not just voting age folks, but is in the totality. So yes, Senator Weston, you're correct.
Thank you.
Thank you. Any follow-ups to that complicated question? Any more comments from the members? Let's see. Okay, we didn't. Okay, so Senator Boldon repeats her motion to accept the A42 amendment. Any more discussion? All in favor, say aye.
Aye.
All opposed? Nay. The ayes have it. We have adopted that motion. Thank you. Senator Boldon, any more amendments or issues?
Mr. Chair, no, I have no further amendments. I look forward to continued discussion, and we'll just mention that in addition to the Secretary of State staff who are here, we do also have some other experts who are joining virtually in case there are questions that would be necessary for. So thank you.
Senator Krantz.
Thank you, Mr. Chair. And I'd like to move the A36 to the A32 amendment to the underlined SF3.
Senator Krantz, can you please, Senator Krantz moves the A36 amendment. Could you please explain it while it's being handed out?
Thank you, Mr. Chair. This one, it's fairly straightforward. What this does is, on page 8, line 11, it removes the section is about not eligible to vote, ineligible voters, and that debt is deemed private. And this simply deletes the word private and inserts the word public. In our conversations, and you were a part of the state gov, and all of the challenges to our elections are, we're moving further away from the transparency than we are moving closer to transparency. And so I think greater transparency is good and allows for the things that used to be available prior to 2008, when that data, and I think until this legislative session, is deemed public. A variety of data is deemed public around the voter status whether you're inactive, ineligible, challenged, or whatever those are. This moves us further away from keeping that public, and thus the ability to go out and make sure that from independent third parties and people have access to statewide voter registration system, that we can validate only eligible people on that database. And so we ensure that everybody who's eligible can vote easily, and to make sure that we have transparency to prove it. So that's what it does.
Senator Rest. Flip your mic on, please.
I didn't mean to interrupt Senator Boldon's response, but I am curious, as you were developing this bill, why you put private data and why you thought that was important in this particular instance of identifying folks who aren't eligible, like, I don't know, a 17-year-old or a 15-year-old, or, I mean, there are a number of reasons why someone is not eligible, but why did you want to keep that private data, which means that they can know it, but it can't be known by the general public?
Senator, Mr. Chair.
Senator Boldon.
Senator Rest. Thank you for the question. My understanding is this is in line with current practice. I think there are a number of reasons why folks may not be eligible to vote that they may not want public. Certainly we want transparency, and there's a reason for that, and in certainly other spaces, through this bill and in terms of voter data that is transparent and public, but in continuity with current practice, I believe, and would welcome the Secretary of State's office to chime in on that. That's why we determined to leave it to be private.
So Mr. Chairman? So,
Senator Rest.
Senator Boldon, I'm inclined to vote against this amendment. I was just wondering, unless you convince me otherwise, do you favor this or not?
I would not favor this. I think, as I stated, I think there are some reasons why there would be reason for that data to remain private. And so for that reason, I would urge a no vote on this amendment.
Thank you.
Thank you, Senator Boldon, Senator Rest. Ms. Freeman, do you have comments on this? And did we publish this information or have this information public in the past?
I don't believe that the data that would fall under this, sorry, Mr. Chair and members, Nicole Freeman, OSS, I do not believe that this data was public in the past. The data that we're anticipating would fall sort of through the funnel as OSS is comparing data with information received under 201.145. Currently, those are reports from the Department of Corrections, folks with felony convictions, as well as those under guardianship, who may have had their right to vote removed. And so if felon restoration passes, I would anticipate that the data that would sort of fall into this category would be guardianship. And so that's sort of a protection measure of keeping that data private, as they're not eligible to vote, and so would not be passed from OSS to the counties.
Thank you, Ms. Freeman. Any comments from members? Senator Matthews.
Well, thank you, Mr. Chair. As the former chair of the Civil Law and Data Practices Committee, where we handled data privacy things like this, I agree with Senator Cran that I think this amendment's trying to move us towards transparency and openness in light of proposed election law changes, and I'm a little baffled as to why the author isn't supporting that, or might I suggest there could possibly be a middle ground in there where perhaps the reason is something that remains private, but the public name is something that's on public data, because that's what the rest of the populace is in the statewide voter database, but otherwise we're closing off an easy door for transparency right here that I think will not help having the strongest, most secure and trusted election system across our electorate in a bipartisan manner that we can. So looking at this with my old data privacy hat that I had for a couple of years, I think the committee should consider doing something like this or finding some middle ground that can get at the intent of Senator Curran's amendment without going all the way to the concerns that Senator Boldon was raised. So I'd encourage the committee to try to dig in on this a little more, please.
Senator Anderson.
Thank you, Mr. Chair. For the Senate Council, could you give us an idea what Section 13.02 Subdivision 12 states? Thank you.
Yes, thank you, Mr. Chair and members. Chapter 13 is the Data Practices Act, and I was just noticing that there's a piece missing from this amendment. So subdivision 1302 subdivision 12 defines private data on individuals, and that is data made by statute or federal law applicable. Sorry, that doesn't make sense. Private data on individuals are data made by statute or federal law applicable to the data that are not public and accessible to the individual and are accessible to the individual subject to those data. So the piece that should be included in this amendment, if Senator Curran is so inclined, is to change that cross-reference to refer to subdivision 15, which is public data on individuals, which means the data is accessible to the public in accordance with the provisions of the Data Practices Act.
Thank you, Mr. Chair.
Follow-up, Senator Anderson.
No, just I think that Senator Curran would like to speak to that information that was just given out. Thank you.
Thank you.
Senator Curran.
Mr. Chair, and I agree with Ms. Stengel, and that would be if we could amend the 836 amendment to reflect that in an oral perspective. That would be my desire.
Senate Council, please reread the amendment as modified.
Thank you, Mr. Chair and members. So to the 836, it would be adding another line. Also on page 8, line 11, delete the number 12 and insert 15. So it will now refer to subdivision 15 instead of subdivision 12.
Thank you.
Senator Curran.
Thank you, Mr. Chair, and thanks, Ms. Stengel. I think that moves us closer to the intent of the transparency needed to establish the trust and building closer to, I think, what our shared goals are than further away from it. So that would be our minute, and I would encourage a green vote.
Senator Rest.
Mr. Chairman, I'm still struggling to understand what part of the data is private data, or what it means in this particular instance would be private. And someone had mentioned, I don't know if it was Senator Curran or Senator Matthews, about the name would be public, but the reason could be private. Is that what's being talked about there? Or when you say something is private data, it's more than just a name. It's everything that has to do with the determining the ineligibility of that person to apply. I don't understand where the line would be drawn. Or would it only be, to start with, just someone's name? And maybe Senator Curran knows that too. Does the term private data mean in this instance that it's going to be name, address, name, address, reason, date of the application, date that it was denied? what does it mean here? I mean, and I would call it, instead of data, what information would be provided in calling something private data? Okay?
Senator Rest, Senate Counsel has an answer for you.
Thank you, Mr. Chair and members. Backing up a little bit, the kind of data that we're talking about here is when somebody would submit an application to DPS for a driver's license, would submit an application to DHS for some services, those sorts of things. So it would be all the things that would appear on a voter registration application, so your name, your date of birth.
I understand.
Your address, all of
Okay.
that.
I get it now, thank you.
And then the data classification says all of that data for people that are ineligible is private, so you don't get any of that data under the way the bill is written.
I see. Thank you.
Mr. Chair.
Senator Cranton.
And thank you, Mr. Chair, and Senator Rest. And really, the goal is not to divulge anything we'd all deem that is private. But if your name is out, your name is public, and the address is public, and the fact that you're ineligible should be made public as well. The reasons, no, I'm okay. That would, right? There's a variety of reasons that those things may occur, and I think, as Senator Matthews said, that's not what we're looking for. But I think to know that it is your inactive or invalid, we got a variety of categories, challenged, and, all those data criteria that go along with it. But I think somehow to move closer to that transparency helps us meet that goal and builds greater trust in the election system.
Senator Boldon, any comments?
Thank you, Mr. Chair, and appreciate the discussion and appreciate the desire for transparency. In terms of this amendment, I am still going to urge a no vote just because of the concerns I have shared. And, as it reads, any data regarding applicants would be public. I have concerns about that, but certainly open to continuing the conversation, and just would remind members that this is our first stop with this bill, and we will continue on to Judiciary as one of the other committees. So look forward to further conversation, I'm sure.
Mr. Chair,
Senator Cranton.
I would like to remind Senator Bolden, this is a first step, but it's absolutely the most important.
Senator Weston.
I have a question for perhaps counsel. Because this deals with issues of data privacy, would that be outside the jurisdiction that we have and fall under the jurisdiction of the Judiciary Committee? So should we even be addressing the amendment? I don't know the answer. That's an honest question.
I don't know the answer to that.
Senator Westland and Senator Cranton. This bill is headed towards judiciary, so I think it would be more appropriately answered there. This is the committee of original jurisdiction, but I think this is definitely something that fits data privacy.
Mr. Chair, I'd respectively disagree with the perspective of all issues are within our jurisdiction in elections. This isn't an election bill. Will it get a more thorough review of data privacy acts? Certainly every member on this election committee who serves on jurisdiction will probably give that as well. But I believe this, I didn't know we had a germaneness determination on a particular issue. It's not like we're in state gov and we're dealing with a particular jurisdiction. This is the election bill, and we are the election committee, and so I think every amendment has the right to be considered.
Senator Cranton, you're correct. My concern, I guess, is that there are consequences to opening up some of this data to people, especially surrounding elections, and especially when we label them as ineligible, because we've had plenty of harassment of people. And every time that we put out something that may suggest that a person could be ineligible, that they might be subjected to more harassment, which tends to be a public safety issue as well. So we can certainly take a vote on this, and it's still going to go to the Judiciary Committee. So thank you, Senator.
Thank you, Mr. Chair, and I appreciate a vote. Thank you.
Thank you. Senator Matthews.
Thank you, Mr. Chair. I'd encourage the committee, we absolutely can consider this topic as we are the original committee of jurisdiction, and we can set, here's what we believe the parameters should be. Bills like this will go through judiciary to get that piece double checked, but we can absolutely make a change to include some privacy or to include some transparency. I think there's ample room between the two positions here to put something on and say this is our goal of getting to a spot where we've got the needed transparency and the protection. And then judiciary has that framework to double check rather than telling them, oh, you just go do all this work instead of us. We are the original committee here. This is a valid issue and concern. I think there's ample room to do what we can all agree on is important here, and I would encourage us to try to do that instead of shy away from it.
Senator Matthews, you are absolutely correct, and we are going to take a vote on this amendment. Senator Westland.
Thank you, Mr. Chair. Thank you, Senators. I asked an honest question. I didn't know the answer to it, and I was curious to see whether this was something we should deal with here or not. I'm going to encourage a no vote on this, and we can bring it up in judiciary.
Senator Cran, was there a request for roll call?
Mr. Chair, I request a roll call. Thank you.
Yeah. Thank you, Senator Cran. Any other comments from the members? The assistant will take the roll.
Okay. Senator Carlson,
No.
Senator Westland,
No.
Senator Curran,
Yes.
Senator Anderson,
Yes.
Senator Barr,
Aye.
Senator Boldon,
No.
Senator Swedzinski.
No.
Senator Dornick. Yes. Senator Limmer,
Yes.
Senator Marty, Senator Matthews,
Yes.
Senator Mitchell,
No?
Senator Port,
No.
and Senator Rest.
Being 8 noes and 6 ayes, the amendment is not adopted. Any other comments from members? Gosh, we're ahead of schedule.
Mr. Chair,
Senator
Senator
Cran.
Lambert, I think there might be a couple other amendments, but we would like to move then to the next phase after the amendments are done into, Mr. Sigurdsson is here, I see, and so we have a variety of issues, I think, on the express advocacy and the foreign corporations.
We have Senator Limmer. Would you like to comment? You're on the list.
Mr. Chairman, as I was reviewing the bill, I know that I don't think anyone wants foreign influence corporations to be involved in elections. But as I'm looking at the provisions, I'm thinking it may be a little too broad, and it may run counter or maybe not properly aligned between federal law and state law. And I was wondering if the author could tell us the differences and then explain why we aren't following foreign, federal law. Why is this different? Why does this need to be different?
Thank you, Mr.
Senator
Chair.
Boldon.
Thank you, Mr. Chair, and thank you, Senator Limmer, for the question. I'm not sure I totally understand your question, but we'll just say in terms of the provision around foreign influence corporations, we know we have a money in politics problem, and this is one attempt to work on that. And so essentially, it says that, foreign corporations, foreign influence corporations cannot spend money in our Minnesota elections, and there are, parameters around that. So I guess I'm not clear on what piece of that you're asking about that does not comport with federal law. If you could elaborate.
Chairman.
Follow-up, Senator Limmer.
Senator Boldon, federal law already regulates and restricts foreign influence. And Minnesota law already regulates and restricts corporate influence. So since law, both federal and state, and it does a double whammy, they are regulating and restricting those two influences. So why is this provision necessary if we already have it in law?
Thank you, Senator.
Senator Boldon.
And thank you, Mr. Chair. I might ask Mr. Ron Fine to weigh in on this, who is joining us via Zoom, who can speak to the differences there.
Thank you, Senator. My name is Ron Fine. I'm the legal director of Free Speech for People. We're a national nonpartisan nonprofit, and I testified at the previous hearing. The gap in the federal law is this. Right now, a foreign entity is not allowed to directly spend its own money in elections anywhere in the United States. So, for example, if the Crown Prince of Saudi Arabia wants to spend money, his own money, in U.S. elections, that's not permitted, including in Minnesota state and local elections. However, if the Saudi Public Investment Fund, which invests heavily in U.S. companies, owns 5% of a share of the stock in a U.S. company, which is actually a substantial percentage of a major U.S. company, nothing in federal law prevents that company from spending money in Minnesota elections, even though the corporate governance decision-making process of that company is influenced by who the shareholders are. As the former CEO of ExxonMobil once said, I'm not a U.S. corporation and I'm not interested in following the interests of the U.S. So that's the gap that this is filling when you have a foreign investment in a U.S. company. The foreign influenced corporation can spend its treasury money, and that is not currently regulated at the federal level or anywhere else in any state.
Thank you, Mr. Fine. Senator Limmer, follow-up?
I'm going to ponder that, Mr. Chair.
Thank you, Senator Limmer.
Mr. Chair,
Senator Krantz.
while Senator Limmer ponders, to Mr. Sigurdsson, when you look at any corporation in this country has no idea on any given day who their shareholders are. And so with the threshold being so low, it could easily meet that threshold in and out on any given day of trading. Could you talk to us about your role in helping determine what this language is, if any? And then two, what do you see as far as even your ability to track that with that criteria being met or not met on any individual day, and what will you use to and do you have the resources to be able to do that? And if you don't have the resources, how many do you believe you're going to need to accomplish that task?
Mr. Sigurdsson, please identify yourself for the record and continue with your answer.
Sure. Thank you, Mr. Chair. My name is Jeff Sigurdsson. I'm the Executive Director of the Campaign Finance and Public Disclosure Board. To Senator Cran's question, I view the requirement for the Campaign Finance Board is to collect the certifications for those corporations that do make donations, that their executive officer, their CEO, is attesting that they were able to make the contribution because they didn't have the 1% or 5% qualifier that would prohibit them from making the contribution to an IE fund or committee. the board would not be trying to analyze, does not have the resources, and frankly, under this bill, I don't view it as being required that we then look at the the holdings of the corporation at any particular time. It's collecting the documentation from the CEO that it was permissible for them to make the contribution. It's basically the limitation of our role.
Thank you.
Senator
Mr. Chair,
Grant,
just quick. So based on that self-attestation then, or that attestation in their annual filing then, they will make the declaration, they will track that foreign source shareholder data on a daily basis or a continuous basis, and then report that to you if they meet the threshold.
Mr. Chair, Senator Cran, I don't believe so. I think it's they attest to that at the date on which the contribution is made. I don't believe they have to look either, well, at any time back prior to the contribution being made. My understanding is the certificate is saying that at the time the contribution was made, the 5% or the 1% was not met. I guess this may be going beyond your question. And then the other issue there is that there are fairly substantial penalties for the CEO if the statement is not correct and already established in 211B.
Thank you, Mr. Sigurdson.
Thank you, Mr. Sigurdson. Council has pointed out that on page 25, there is a requirement, line 17, certification must be submitted within 7 business days after the contribution or expenditure is made and must be signed by the corporation's chief executive officer. So there is some self-attestation there and the timing as well. Other comments or amendments? Senator Marty.
Mr. Chair, I think it's a great bill. I'd like to have Senator Boldon move the bill and let's vote on it.
Mr. Chair.
Senator Grant.
So, Mr. Chair, I think on the other issue, not the foreign court, but the express advocacy, when we look at the express advocacy, I have a few concerns from the perspective of that it appears to be pretty broad, at least in the initial conversation of, we had the definitions and the word right, the definitions of words and phrases, and I'm worried about, it appears to be a little bit more broad than what we used in the past. And I think Mr. Sigurdson did a good job at those that are following outside of the, outside that aren't reporting, and then when and how can we tighten up the language to make sure that everybody understands who currently falls in the express advocacy, how that decision is going to be made today, because it appears to be a little bit more broad. And then is there any tie to, issue advocacy, which, there's a variety of people that do that. I'm worried about how broad that may, or how many people it may encompass, and then who will be the arbiter, because some of it appears to be subjective in the language. And so can we tighten that up so everybody understands what the rules are that we're playing by? I think the goal would be to identify everybody. But right today, I don't think the rules are clear enough for us to feel good that people will be able to meet that criteria as stated. So.
Mr. Sigurdson.
Mr. Chair, Senator Cran, my understanding is that this is very closely modeled after the federal language. The Federal Election Commission has been using the functional equivalent standard for quite some time, as has a number of states. The board's recommendation on this area is a little different in terms of language, but it's two roads to the same destination. I would say that the majority of independent expenditure committees and funds, frankly, are fairly sophisticated actors. I mean, we are talking about $63 million in Minnesota in 2022. I understand that sometimes there's the conception that we may be dragging in people who made an innocent mistake, and I suppose the answer would be then they'll need to register and report if they cross that line. But for the majority of entities, frankly, they are, I believe, sophisticated actors, and they understand how this works at the federal level. and will not find it particularly hard to meet that standard in Minnesota. To your second question, I believe was, in the end, who makes the call under this bill? It would be the Campaign Finance Board. There is a number of court cases that have looked at this statute and similar statute, and those courts have given direction to committees like or organizations like the Federal Election Commission and various organizations like the Campaign Finance Board in other states in terms of what they should be looking at. They should be looking at the perception of the audience, not the intent of the speaker. There is some other lines that they provide in terms of, this is the sort of thing that you need to think about when you're reviewing the particular communication that's in question. I guess I would emphasize, though, that this is not an initial attempt to go into functional equivalent. This has been out there for many years at both the federal and in other states as well.
Thank you, Mr. Sigurdson. I appreciate it. Mr. Chair, movement on the foreign, back on the Foreign Corps, I'd like to move the 835 amendment. The 835 amendment to the underlying 832 amendment.
Senator Cran moves the 835 amendment. Senator Cran, could you explain the amendment as it's being passed on?
Thank you, Mr. Chair. The amendment has to do with the Foreign Corps, and on page 23, line 30, and on page 24, line 2, it moves the percentage from 1 on line 30 to at least 50, and from on page 24, line 2, from 5% to at least 50. And I encourage a grain vote.
Mr. Chair.
Senator Boldon.
Thank you, Mr. Chair. Members, I would encourage a no vote on this amendment. These numbers, so the 1% for an individual and 5% for 2 or more individuals were actually taken from some data and research around this topic to show that the sort of the threshold for when there is influence in a corporation occurs at those percentage levels. So it was with intent that those were chosen, and I would encourage members to vote no on this amendment.
Senator Port.
Thank you, Mr. Chair. Thank you, Senator Boldon. I also encourage a no vote on this. This is a piece of campaign finance law I have worked on for many years and done a lot of research on, and this can be a significant amount of money. 1% of a Fortune 500 company is a huge amount of money, and they can have significant both outside interests that are not based on our interests here in the United States, and they can have a significant voice in the company. I encourage keeping it as the language states, which has been, as Senator Boldon said, researched and tested.
Any other comments about the, what is it, the A35 amendment? Senator Limmer.
Thank you, Mr. President. Mr. Chairman, sorry for the promotion.
Thank you, Mr. Hoffman.
Must be Freudian slip of some kind. Senator Boldon, or anyone else, I see that on line 23.29 makes reference to a single investor, a single foreign investor of 1%, but out of 100%, there may be other investors in that same pool that would have either the same intention or maybe the opposite intention. And 1% doesn't seem, although it may be a large dollar amount, it may not represent the type of control that one might think. And so how can a 1%, I need to define this, how can a 1% share have the control of a political intention when there's other investors that could in fact counter that intention. I would think a larger figure would be more obvious of what we're looking for. Tell me how you arrived at that 1%.
Senator Boldon.
Thank you, Mr. Chair, and thank you, Senator Limmer. So again, I would just go back to this language came from research and data that has shown, as Senator Port said so well, there is evidence to show that having a 1% share in a Fortune 500 company and a large corporation does provide influence. And so there may be other counterbalances, or there may not be, but there is solid data to show that a 1% investor does have influence, and it does rise to be at that level. So that is why that was chosen.
Well, Mr. Chair, could you tell me the research
Senator Limmer.
Source that you're claiming?
Senator Boldon.
Thank you, Mr. Chair. I'm happy to provide that. I don't have it in front of me, but I'm happy to get it to you.
Well, Mr. Chair,
Senator Limmer.
if we don't have the source of the claim that we're trying to judge, it makes it very difficult for me to come to a conclusion of whether or not that's a reliable source or not, if it's not in front of us.
Mr. Chair?
Senator Boldon.
Yeah, I was provided that information. Center for American Progress 2019 report.
Is there a title to that report? I'm assuming they might make more reports than one in 2019.
It's coming. I don't have it in front of me. Someone will send it to me.
All right.
I'm happy to provide it.
Senator Limmer, follow.
I'm not familiar with that source, Mr. President, or Mr. Chairman.
Senator Port.
Thank you, Mr. Chair. And, Senator Limmer, along these lines of questions, I think you actually answered it for us earlier, because you said at the beginning of this hearing that it is something we can all agree on, that we do not want foreign influence in our elections. So 1% of foreign influence in our elections is too much. So, the fact that it may have counterbalances, it may not. But if we are going to allow a threshold at which foreign powers know that they can spend money on our elections, these are not unsophisticated organizations. They understand how to work amongst the rules that we have. And so it is critical that we have strong guidelines in place to make sure that people know that our democracy is not a place where we are open for business for foreign influence on our democracy.
Mr. Chairman?
Senator Limmer.
I happen to own a corporation, but...
Please speak into the mic, Senator Limmer, real closely. Thank you.
I happen to own a corporation, Mr. President. It has two owners, my wife and me. And if my wife was a citizen of Canada, would my investment as a corporate owner be a violation? And I'm not sure if it has a lot of influence, because my corporation is very, very small. And so is this a total recognition? I would imagine there's a lot of corporations that may have one relative that's investing in a tiny little corporation, and does that bar any influence under the federal allowance?
Senator Boldon, can you comment on that?
Thank you, Mr. Chair. So I'll just sort of reiterate the policy, in this bill says that, if a corporation reaches that threshold of 5% influence, then, that they would be included under this bill. I would say if you're under this hypothetical scenario, if your wife is a dual U.S. Canadian citizen, it would not apply. But if she is only a Canadian citizen, then it would. Again, with the goal of, we don't want foreign influence in our elections. So that's.
Senator Port.
I think Senator Boldon answered that.
Thank you. Senator Marty, I had you on my list as well.
Mr. Chair, just a brief comment, and that is if Senator Limmer or others, I mean, the corporation doesn't have to make the contribution. You could make the contribution on your own, but if you do want a corporation to make it, let's keep the foreign investment out of it, and depending on whose research it is, vote against the amendment, vote for the amendment if you think it's too low, but I think it's a bad amendment. I think the bill is great the way it is. We don't have to question if the results, the study that makes her come up with the 1% and 5% is appropriate or not. Just vote for the amendment if you support it, vote against it if you think the bill is good, and I think the bill is pretty good.
Senator Limmer.
Let me go back to my hypothetical. If my wife and I, who are the only investors in a corporation, recognize that I only had 1% ownership in that corporation, let's assume I'm a citizen of a different country, I'll assure you I don't have control of that corporation. And if you know my wife, you'll definitely agree with me. But so I guess the question is who actually controls a company? Does a 1% shareholder actually control the corporation, or does it not? And I think we're being a little generous to make that assumption. But we want to put that same assumption in law. That's the difficulty I have with that.
Mr. Chair.
Senator Boldon.
Thank you, Mr. Chair. I would just posit that we're not talking about control, we're talking about influence. And so, again, I'll go back to there's evidence and data to show that those with a 1% share have influence in a corporation.
Is that, it's carried through here. Senator Limmer, on page 24, line 17, it does define a person as an individual outside of the United States who is not a citizen or national of the United States and who is not lawfully admitted for permanent residence in the United States, or, and then it goes into a foreign investor. So there's a couple of ways that a person can disqualify themselves. Senator Matthews.
Thank you, Mr. Chair. Senator Boldon, is there an example of a corporation that, due to a 1% or 5% share, started making influential changes in what they're advocating for?
Senator Boldon.
Mr. Chair, Senator Matthews, I'm sure there's lots of examples of those. Do I have one in this moment to share? I do not. Again, I'm happy to share the reference that I mentioned. It's actually Ending Foreign Influence Corporate Spending in U.S. Elections, Center for American Progress, 2019. And happy to share that out with anybody via email. So do I have a specific example in my mind in this moment? I do not, but again, I'll go back to there's data and evidence to show that folks who have a share in a corporation have influence within that corporation, and as Senator Port said so well, in large corporations and certainly Fortune 500 corporations, 1% is a lot of money.
Mr. Chair.
Senator Matthews.
Mr. Chair, Senator Boldon, do you know who founded the Center for the American Progress?
No, Mr. Chair.
Mr. Chair, Senator Boldon, do you know who is running or chairing Center for the American Progress?
Senator.
Mr. Chair, can we vote instead of discussing who's running certain organizations that I think is irrelevant to the amendment?
I think we have gone off the rails here.
Mr. Chair.
Senator Matthews, I think Senator Marty has a very important point.
This is very relevant to the amendment that we have here. Mr. Chair, the front page of a simple Google search shows it was founded by John Podesta. The chairman right now is Tom Daschle, former Senate Majority Leader. John Podesta was campaign manager for Hillary Clinton, among other roles. This is the one source being cited. The homepage says, right on the front page, a public policy research organization that presents a liberal viewpoint on economic and social issues. Surely there has to be one example of influence, and the answer I get is, well, there must be lots and lots of them, but I can't think of one. I'm wondering if we have a more unbiased viewpoint and some concrete examples that we could bring up that's backing up the claims made in this committee. That's the point I'm getting at, Mr. Chair, so that we know that we're actually solving a problem that exists in the real world. Otherwise, perhaps we should consider, is there some limitation to the Fortune 500 companies are the ones being frequently mentioned? That's definitely going to be a much higher threshold than a very small local company that may be publicly traded. And this is viewpoint neutral, Mr. Chair. This could be a corporation that has viewpoints across the political spectrum, could be those on the right, could be those on the left. I'm keeping viewpoint out of this for the underlying policy of what threshold do we have. So I would like to see the research provided. Seems to not be from a very unbiased source. I'm wondering if there are other sources and if there are real life examples that show that we have a problem here in this area.
Senator Boldon.
Mr. Chair, if I could, I would invite Mr. Fine to weigh in.
Mr. Fine.
Thank you, Senator, for the opportunity. And I'm sorry that my written testimony, which I timely got in on the House companion bill, I may have missed the deadline on the Senate side. The 1% threshold was selected because until actually quite recently, that was the threshold for investors to submit a shareholder resolution to publicly traded corporations. And what happened was Congress, on a bipartisan basis, and then the Securities and Exchange Commission, as well as major organizations like the Business Roundtable, which represents CEOs of major companies, all agreed that that was actually too high a threshold for submitting shareholder resolutions. Representative Jeb Hensarling, a Republican of Texas, sponsored legislation to lower it from 1% to well below 1%. Eventually, the Securities and Exchange Commission did that by rulemaking. And what they concluded in their rulemaking process accords with something that major investors can tell you informally, which is that anyone who owns 1% of stock in a major company can get the CEO on the phone within 24 hours. 1% of a S&P 500 company is, if the company is doing poorly, you're talking at least $50 million to own 1%. But for most companies, it's in the hundreds of millions of dollars of stake. Most major companies have only a handful of 1% shareholders. It's rare. Some don't even have a single 1% shareholder. And the CEO could probably tell you by heart at any given moment who owns 1% of the stock. They're that influential. And so this is not to say that every 1% shareholder is going to be lobbying the CEO, any more so than we would say that any major campaign contributor is going to be asking for specific policies from elected officials. But just like, and I'm not speaking of this Senate body in particular, but just like in general, elected officials know who their major donors are and what they want and what might anger them, and certainly know what their constituents want and what might anger them. CEOs are generally aware of the concerns of their largest investors and tend to avoid trying to take actions that would be at cross purposes with them. And that's the mechanism for foreign influence. It's not that every single 1% investor is on the phone with the CEO saying, I want you to spend in this particular Minnesota race. It's rather that the corporate management shifts its perception of who it's responsive to these larger foreign interests. One last thing I want to say is small local businesses very rarely have substantial foreign investment. I won't say never, but it's quite rare. This is mostly an issue with the very largest businesses, sometimes a joint venture between an American company and a foreign company, but usually we're talking about the very largest businesses that will have substantial foreign investment. So I hope that's helpful, and I apologize for not being able to get my written testimony, which laid this out in much more detail on time to this committee.
Thank you, Mr. Fine. I think we have discussed the fringes of this amendment, and I think we know approximately what may come out as a vote. And so I'm going to move that I'm going to call for a vote on the A35 amendment.
Mr. Chair, request a roll call.
And roll call has been requested. Roll call accepted.
Okay, on the A35 amendment, Senator Carlson,
No.
Senator Westland,
No.
Senator Curran,
Yes.
Senator Anderson,
Yes?
Senator Barr,
Aye.
Senator Boldon,
No.
Senator Swedzinski.
No.
Senator Dornick. Senator Limmer,
Yes.
Senator Marty,
No.
Senator Matthews,
Yes.
Senator Mitchell,
No.
Senator Port,
No.
Senator Rest.
No.
There being 8 noes and 6 yeses, the amendment is not adopted. Senator Boldon, any other comments, issues? We're ready to vote on the Senate file number 3.
Mr. Chair, request a roll call.
A roll call has been requested. Roll call accepted. As amended. Sorry, Senator. Thank you, Senator Rest. This is for the Senate file 3 as amended, and it will be sent to transportation.
Mr. Chairman, I have a question.
Senator Limmer.
Thank you, Mr. Chairman. So in this legislation, how are we defining election speech and lobbying speech? Do we allow the Campaign Finance Board to make that definition? Or are we defining it in this bill?
Senator Boldon.
Thank you, Mr. Chair. Thank you, Senator Limmer. Can you point me to a line in the bill that you're asking about?
I don't have that right in front of me. I was reading it earlier on my own copy, and I made notes, but I left it in the office. Perhaps Mr. Segerson could answer that question.
Mr. Sigurdson.
Mr. Chairman, Senator Lambert, I'm sorry, sir, I didn't hear the last part of your question. Could
The
you?
way, Mr. Chairman, the way
Senator
you
Limmer.
understand this bill, does the Campaign Finance Board, is it relegated and given the authority to define what is election speech and advocacy? Or is that allowed by or defined by the legislature?
Mr. Sigurdson.
Senator Carlson, Senator Limmer, that would be the expressly advocating section, which is basically saying that political speech is now both that speech which uses the expressly advocating terms, the vote for, vote against, and then going also to the functional equivalent standard, which is terms that can be used in, there's really no other way. I want to get the language in front of me. When taken as a whole and limited reference to external events such as proximity to the election, could only be interpreted by a reasonable person as containing advocacy for the election or defeat of one or more clearly identified candidates. Again, that's the federal standard. So that would be, through this legislation, the standard that the board would apply.
Thank you.
Thank you, Senator Limmer. Thank you, Mr. Sigurdson. Senator Matthews, quickly.
Thank you, Mr. Chair. Quick question for Mr. Sigurdson. You mentioned earlier that it was mirroring FEC language in the disclosure, the equivalent language that you mentioned. But does the FEC have mirroring requirements of donor disclosures based on that standard, or certain things that are found in this bill?
Mr. Sigurdson.
Mr. Chair, Senator Matthews, the disclosure requirement for political funds or independent expenditure funds and independent expenditure committees is not affected by the language in this bill. It remains the same for the state of Minnesota. In terms of, is it comparable to the FEC? Yes, sir, it is. We both entities require disclosure of the source of funds used for independent expenditures at the federal election level, obviously by the FEC, and at the state level by the board. I'm not sure if I can answer exactly what you're saying in terms of the disclosure be the same, because we have a somewhat different standard for the amount that has to be disclosed by an independent expenditure fund. I think the threshold here in Minnesota is higher. It's only those sources of funds of over $5,000, and I believe that it's less than that at the FEC, but I apologize if I get that wrong. But I believe in general the Minnesota standard for disclosure, itemized disclosure, is actually higher than at the FEC level.
Mr. Chair, just briefly.
Follow-up, Senator Matthews.
I think there's grave free speech First Amendment considerations in this bill. If you go get your Constitution and pull up the First Amendment, there's no disclosure clause to allow you to have the speech that the Constitution entitles you. I think there's some serious issues with this underlying language. It needs to get vetted out, that needs to get fixed, that needs to get ironed out. Otherwise, this bill will be an attorney employment insurance act for the next few years, which is none of our desires here. So we hit on that issue a little bit. It needs to be worked out and changed as this bill moves along. But as it stands right now, there are serious First Amendment concerns in this language. Thank you.
Thank you. Thank you, Senator Matthews. The clerk will take the roll.
Senator Carlson.
Yes.
Senator Westland.
Yes.
Senator Curran.
No.
Senator Anderson.
No.
Senator Barr.
No.
Senator Boldon.
Yes.
Senator Swedzinski.
Yes.
Senator Dornick. No. Senator Limmer.
Nope.
Senator Marty.
Yes.
Senator Matthews.
No.
Senator Mitchell.
Yes.
Senator Port.
Yes.
Senator Rest.
There being 8 yeses and 6 noes, the bill is passed and sent to the Transportation Committee. I want to thank everyone for the spirited discussion, and thank you. I think we made a better bill. We had some bipartisan amendments, and that's what we need. And I'm sorry, Senator Matthews, I'm sorry that this might be a jobs bill for your particular career, but we'll probably see that later. So thank you, everyone. That's that completes our agenda. The meeting is adjourned.